Could this incident have been prevented? That's a question that I ask as well. And accordingly, I have directed Alberta's Deputy Attorney General to review any involvement of the Alberta Crown Prosecution Service that they had leading up to this incident, with a view to determining if any processes could be changed to help prevent a repeat of this tragic, unfortunate, and needless crime.
That was Alberta's Attorney General Jonathan Dennis responding to the shooting of two RCMP officers by a serial violent criminal named Shawn Raine. Dennis is calling for a full review of why Raine was out on the streets instead of behind bars. His extensive list of crimes dates back to 1999, and despite his criminal past, he was released on bail as recently as September 4th, 2014. And what's worse, the Crown, the prosecutor, did not object to his bail on at least one occasion. Take a listen.
What is the Crown's position then, please, on release?
Your Worship, we have agreed on a joint release in the amount of $4,500.
I'm prepared to release you, Mr. Wren, as recommended by both Mr. Mustera and Constable Kwan.
Criminal defense lawyer Ed Prucci joins us now to take us through the series of events that put Raine on the streets. Ed, great to see you again.
Good to be here.
We heard the audio tape because these days most courts don't have a live stenographer. It's just an audio tape recording that is kept, and that was actual courtroom sound of the bail hearing that put Raine on the street. Now, what's interesting there, and I'm going to throw this to you in about 1 second, is that the Crown, in the form of a cop, agreed to bail. And I guess the second thing is that it wasn't a Crown prosecutor, it was a policeman himself. What do you make of all that?
Yeah, that's exactly right. There's a few interesting things. So as an Ontario lawyer, the first thing that stands out is it's completely foreign to me to see a police officer placed in the stead of the Crown advocating on a bail hearing. I know that that is fairly common actually at first instance bails in Alberta, but it's certainly not something that we see in Ontario, not in the major city centres.
Now, a cop, I mean, obviously, you know, would be an advocate against the criminal, but a cop might not know all the ins and outs of the law. I mean,
well, there's a couple of problems. I mean, one, I've got issues just from a conflict perspective. The idea of having a police officer, oftentimes these bail hearings are about whether you believe the police officer, you believe the accused, is there misconduct by the officer, how far are they in the investigation? But also from the police officer's perspective, it's a little bit unfair almost to put him or her in that position, because if you've got a trained lawyer on the flip side arguing the legalities of it, that's frankly not the police officer's role.
Yeah, exactly. I mean, I found that quite puzzling. But as you say, that's normal. So let's not quarrel with that. Sure. But let's talk about, before we get into some more of the facts about Raine, can you give our viewers a bit of a primer on bail? It's we talked about this the other day on the show, but let's go deep on it with you, because you do a lot of bail.
Yeah, so a few things to remember. First of all, I mean, a person in a bail situation is presumed innocent. They haven't yet been convicted of the crimes that they're there for. So there's a presumption, generally speaking, that a person is entitled to a reasonable bail, and it's the Crown's obligation to prove on a balance of probabilities and beyond a reasonable doubt that they ought to be kept in custody. Now, having said that, if is
it on balance of probabilities or beyond reasonable doubt?
On the there's a two-part test when it comes to bail. They've got to show either that a person is going to fail to appear in court, so they're not going to come back, or they're going to fail to comply, and there's a substantial likelihood that they're going to do one of those things. That's the language that the criminal code uses and that the precedents in law use.
Got it. So if you've never been in trouble with the law before, first time you're charged,
you're probably getting bail unless you're facing something very serious.
Because it's the Crown that has the onus to prove you should stay in. But here's the thing with this guy, Raine. He had been in trouble with the law so many times before, about 100 charges, and he broke his bail conditions and his probation conditions so many times before. Would the onus be switched this time?
So what switches the onus in his particular case is not even his lengthy criminal record, even though that record included failed to complies for other bails. The problem he has from a what's called a reverse onus perspective is that he was already on bail when these charges came forward. So he had already been released on one bail. In fact, if we follow the chronology, he had been released on two. This was his third time up. So if you're already out on bail and it's now alleged that you're committing new offenses, you don't get the benefit of what's normally a Crown onus. The burden shifts. You now have to show why you ought to be released.
Got it. So if it was a first-time offender, you'll be let out because the Crown, the government has to prove that you are a risk. In this guy's case, it would be assumed he was a risk. He had to prove he could be trustworthy. And yet what we heard in that recording is that the police officer standing in the place of the prosecutor agreed that he could go. Like, it wasn't even the judge. I mean, the judge approved it.
The judge goes along with what the two counsel, in this case, one police officer and the defense
so
counsel.
if a cop is going to say, "Oh, Your Honor, this guy can go. It's fine by me. Just $4,500." If a cop says that, I mean, you can understand why a judge would say, "Well, if the cops want this guy to go, okay, fine."
I mean, there is a residual obligation and power on the part of the justice of the peace who's hearing the decision. In this case, it was a woman. She could have said, "You know what? I got questions with this. I've got concerns." She didn't, and that's understandable. She took the word of the two lawyers who had negotiated this out, or one lawyer and one police officer. What's interesting is if we rewind a little bit on the previous bail hearing, it's not clear whether it was an officer or an actual lawyer in that circumstance, probably a police officer, but in that case, the Crown attorney had requested his detention. So we had actually gone backwards. He was in more trouble now, here facing his third bail, and yet this third time around, for whatever reason, the officer concludes that a consent release, meaning the Crown is fine with this, was to go, whereas the previous time the Crown had actually fought somewhat hard to say, you know what, this guy is a risk. I think he ought to be kept in custody.
I want to ask you one last question. The other day I did a monologue and I said, look, we got three branches of government: elected legislators, those are your MPs. We have your executive, those are your cabinet ministers who run the government. And the third branch of government are the judges. And if this screw up that caused a death and another shooting had been done by a politician, there would be outrage, especially in the media. Do you think, Ed, that it is legitimate and fair that the judge, that third branch of government, the judge who let this criminal go, in the case you referred to where it was contested, and the judge even here who asked no questions, is it fair game that we scrutinize the judge who put this person out on the street, that we name them and maybe even shame them? Is that fair?
Well, I'll go halfway with you on this one. We're certainly entitled to scrutinize. I mean, these kinds of decisions and armchair quarterbacking is a little bit easy, but it's fair game. Judges have a difficult job. They've got to make tough decisions on the fly.
And that's what they get paid the big bucks.
And they do get paid well, and they are well remunerated and trained for this. So, I'm not going to feel bad for a judge who comes in for some criticism if the judge was ultimately wrong. But in the very next breath, what I will say is it's not easy when you're looking at these records, when you're looking at this background and making a decision on the fly. These hearings were each about 15 minutes long, and that was it. Not a lot goes into that kind of process because so many of them come up each and every day. You obviously are taking a degree of risk, and the reality is that on any given day, the vast majority of people granted bail, no matter how long their records are and how many times they've failed to comply in the past, most people get by on bail just fine, even if they're later on convicted. The stats in Ontario, I believe, are roughly 85%. I don't know how that works in Alberta, but we may be able to extrapolate to that. So most people, you give them bail conditions, you tell them to follow it, they sit out for 6 months, a year before their trial comes up, and they're just fine. Obviously, a small percentage of people, that's not the case. And in this scenario, the consequence was absolutely devastating.